Hi, this is Robert Robles, attorney for U.S. Law Shield in the state of Oklahoma, and I'm here to talk to you about civil liability in the state of Oklahoma. Let me assure you first off that you can be sued in a court of law in Oklahoma for civil liability if you're involved in a shooting or assault and battery with a firearm, or if you defend yourself using any type of secondary weapon such as pepper spray or a stun gun. And I will also tell you today that the state of Oklahoma does have civil immunity laws in addition to criminal immunity laws under the Castle Doctrine and Stand Your Ground laws. But those immunity laws do not prevent a lawsuit from being filed against you in a court of law, and what is required is that you go to court to defend yourself, hire a lawyer to defend yourself. Otherwise, the court may assess a default judgment against you if you do not go to court to defend yourself. One major point to make before I close is that you can be held liable in a civil court even if you were not charged or if you were acquitted in your criminal case if the issue of immunity was not brought up as part of your defense. What does that mean? That means that if the jury returns a verdict of not guilty because you had self-defense and your lawyer never argued for civil immunity under the Castle Doctrine or Stand Your Ground law, you will not have been granted civil immunity by the courts, and that is an issue to be decided. If you are sued civilly, you must have a hearing in front of the judge, bring up the issue of immunity, and the judge has to rule in your favor in order for you to win the point of you have civil immunity, and the judge would throw the case out.